Hello, everyone. One last set of congratulations to the, I believe, 26 newly qualified landscape architects who were here today out of a class of 75 representing the 3 years that we had to celebrate, 2 years of which were delayed because of the COVID period. Please join me in welcoming Paul DeGrief tonight. Paul is sitting down here in the front row. He was recently appointed as the chair of the BCSLA Professional Governance Act Working Group, and he will be moderating the question and answer portion of this event. The session will be streamed and recorded, so please remember to silence your devices. Tonight, we are honored to have Paul Craven, Superintendent of the Office of Professional Governance, join us. Paul began his legal career in Vancouver, practicing commercial and business litigation in a wide range of areas, including professional regulation and administrative and corporate law. He then served as Executive Director of Federalism and Canadian Intergovernmental Policy at the Intergovernmental Relations Secretariat and the Office of the Premier. After that, he served as Executive Director of the BC Environmental Assessment Office, leading the Strategic Services and Compliance Division, which administers the Environmental Assessment Act. And then he led a team responsible for the revitalization of the assessment process. This resulted in the passage of the new Environmental Assessment Act of 2018. Paul was appointed Superintendent of Professional Governance in June of 2019. And since that time, he has been leading the implementation of the Professional Governance Act, providing regulatory bodies with the tools necessary to regulate professions in the public interest and within a modern framework. He has also been working to ensure there is an ongoing dialogue between the regulatory bodies and the provincial government. This session is being live streamed and recorded, so once again, please be aware of that. Please join me in welcoming Paul Craven.
Thank you. Good evening, and my pleasure to be here with you this evening as part of your conference. And hopefully by the end of my sort of little talk and our Q&A, you'll have a little bit more shared understanding of the Professional Governance Act. So what I'll work through, and just in terms of some general background on Professional Governance Act and my office, the Office of Superintendent of Professional Governance. We'll talk a little bit about some recent updates to the legislation that we brought in, and also look ahead a little bit in terms of the role and the impact on your organization. So we'll work through this, and fortunately I can't see that at this angle, so I'll hopefully keep up to date here. So Professional Governance Act was brought into force in 2021. The basic idea of the Professional Governance Act is it brought together in a single statute, a single regulatory framework, statutes for the engineers, for the foresters, technologists and technicians through ASTTBC, and a total of 5 regulatory bodies. We're also in the process of bringing the architects under the Professional Governance Act. So instead of having each having their own individual act, they're all under the Professional Governance Act. So that's in creating this common governance framework for regulated professions. And our focus generally is in the area of natural resources and the built environment. So that's our, all the professions that we're dealing with presently are sort of connected in that way. So in addition to those regulatory professions, those 5, soon to be 6, there is an ability through the Act to add other professions. And that's a process called designation. And I'll talk a little bit more about that at the end. And that's going to be of most interest to you. So the office itself was established under the Professional Governance Act. Our role generally is to promote consistent and independent oversight of regulatory bodies. We are responsible for administering the act, and we have this dedicated office to support best practices in professional governance. We sit in the Ministry of the Attorney General, and my role as superintendent gives me certain authority under the act to do certain things. But we're not involved in the day-to-day operation of the regulation of the profession. We're there to provide oversight to ensure that the public interest is addressed, but the day-to-day attributes that you have in terms of what a regulatory body normally does continues with those regulatory bodies. Okay. So we also are independent from the ministry hierarchy. So when I exercise authority under the act, I'm not exercising that as the Ministry of the Attorney General, but as my authority as the superintendent. So the million-dollar question here is, why is professional regulation important? And as members of this society, I think you already have an appreciation of that. But self-regulation generally is a privilege granted to professions, various ones, through legislation to protect the public interest. It recognizes that certain professions, certain occupations are so closely tied to the professional, to the public interest, that they require a form of regulation. But instead of that regulation being provided directly by government, it's delegated to a regulatory body. So registered professions are regulated by that professional regulator and have that ethical and legal duty to put the interests of the public ahead of their own personal interests. It's a defining characteristic of professionalism and of the professions that are under the PGA. So part of that, in an exchange for being regulated in this matter, there's usually rights that are conveyed to that profession. The two that you commonly hear about is right to title, the right to exclusively call yourself a particular profession, whether that's professional engineer or architect, or in the case of landscape architect, right? And that's a signal to the public that that individual has certain professional and educational attributes that can be relied upon. There's another concept that's really important, and that's the idea of reserved practice. Now, that's not always the case, but what reserved practice means that only that profession can occupy and do certain things. So on one hand, you can call myself that particular title. I'm the only one allowed to do that. And then a further element of that is I am the only one to do these certain things. And the reason and the basis for that is, of course, that there's a public interest associated with that, usually in relation to safety of the public, right? And the concepts of engineers, if you have somebody who is an unqualified engineer and doesn't do their job properly, bad things happen, right? And various degrees of that in various professions. But that's sort of the common attribute. And of course, by signaling that you are a profession and a professional with that particular title, you're signaling to the public that I am an individual that could do that job. And that helps the public in terms of they know where to go to be provided professional services and be assured that their interests are going to be addressed, and also have a mechanism for those interests to be addressed when things do not go right in terms of a discipline process, a complaint process. And also key elements of a professional regulator, of course, are entry into the profession. So we had our book awards today celebrating individuals who are entering into the profession. So that's a key element of the regulator. Continuing practice, continuing education, ensuring practice standards to that profession, and complaints and discipline. But the focus primarily, we can talk a lot about coming into the profession and complaints and discipline. But the key and core is where you spend the bulk of your career, which is serving the public and providing those practice standards and assuring the public that you're providing a service of value and within the standards of that profession. So our general goal at the OSPG, in collaboration with the regulatory bodies and with individual registrants, That's what we call individuals who are registered under regulatory bodies under the Professional Governance Act. It's this shared interest to have effective, trusted, and supported professional governance that protects the interests of British Columbians. That's our combined goal. So the Act itself was brought in prior to the introduction of the office in 2019. But from that point on, we were working with regulatory bodies to implement the PGA. And in that course of implementing the PGA, we identified some areas based on that operational experience that we wanted to add and make some amendments to the Professional Governance Act. So in a recent legislative session, amendments were brought through and passed by government. And they're broadly in these categories: improved operational efficiency and effectiveness, best practices of professional governance, and a term that you'll hear us use a lot, which is right touch regulation. The importance of right touch regulation is certain professions, require some level of regulation, and other professions or occupations require less regulation. And what we want to aim to is hit the right spot, the whole Goldilocks theory, right? That bowl in the middle that is just right. So just a little bit on these areas, sort of in terms of improved operational efficiency and effectiveness. Some of the items that we dealt with. The ability for regulatory bodies to address registrants' non-compliance with administrative matters outside the discipline process in a way that's procedurally fair. What does that mean? Well, in situations where often or you may find that a registrant doesn't pay their annual fees. Instead of having to go through a whole discipline process to do that, a more automatic process that leads to consequences, but also has an easy way for the registrant to rectify that, as opposed to going through a full discipline process. There's an update to declarations framework under the Act. This is an area where the Act allows us to require that certain declarations have to be made. Declarations with respect to conflict of interest, for example. And there's a whole regime related to that. But when the Act was initially introduced, it was very general. And the only way to bring it in was essentially for every project, you would have had to file one of these declarations. And we felt that was too blunt of a tool. So we've narrowed and provided some flexibility. So if we ever need to use that tool, it's much more effective. Committee chairs play a really important role in the various committees of the Professional Governance Act, whether that's credentialing or the discipline process. And so the process for the selection of those chairs was fairly onerous under the Act. So we loosened some of those requirements, so it was less prescriptive. And then there's some technical definitions in terms of regulation of firms. So the Professional Governance Act is really focused on the regulation of individuals, but it also has authority for regulatory bodies to regulate firms. So that is in the case of only one instance of that right now. That's the engineers have recently introduced regulation of firms, and they've been they were seeking that ability for I think probably over 20 years out of some incidents where they felt it was necessary to regulate firms as well as the individual. And that's one of the things that is really important, is one of the attributes of the Professional Governance Act and having the Office of the Superintendent of Professional Governance. Because generally what you will find is if you are connected to a particular ministry, you are competing with all the other ministry priorities. So professional regulation doesn't get as much attention as it necessarily deserves. So you would have the engineers or the architects or some of the other bodies seeking amendments to their act, but never getting them through because other priorities take place. And you were always competing with You'd have a policy analyst in a particular ministry that was responsible for landscape architects, but they're also responsible for several other things. And while professional regulation of landscape architects is important, vis-a-vis other things, and generally landscape architects, being the great landscape architects they are, don't cause front page news most of the time. So it gets down to further down the pile. Well, at least I hope so. So that is a sort of a key element of the Office of the Superintendent. We are there to support regulatory bodies, what I like to say, on a 24/7 basis. Please don't call us on Saturdays and Sundays. But that is part of the element of our role. We also can do investigations and audits in under our role related to particular things, and we wanted to clarify our authorities related to that. Just in terms of some best practices and terminology, a key element of the Professional Governance Act is switching the mindset from membership to registrant. So membership organizations, by their very nature, introduce a conflict of interest in the sense of, are we doing this for the member? Or are we doing this for the public? And as you move to a more public interest element related to that, then we're introducing terminology like registrant. And we also made some changes around this in terms of the organization. So moving from president to chair, that type of thing. So those changes have been made. Updating some rules and motions from motions on the floor of annual general meetings. You're moving to a scenario where the board is responsible for bylaws as opposed to the membership and the registrants. So annual general meetings are still a component under the PGA, but they're not in a position to be passing bylaws, which also leads to a more effective regulatory organization. So I'm not going to go into sort of some of the other details, but all of these presume a level of knowledge with the existing act. So they are enhancements to the existing act. But I think probably what we should spend most of our time is making sure that you know the general thrust of the act and why it's important and what it does. So, but I do want to touch again on this concept of right touch regulation, and it's what we've done in this latest act amendments is to ensure that we have some authority to disapply certain rules so that we can have a better fit for a particular regulatory body and a particular profession. I should touch on this. In the previous act, in the early version of the act, there was no authority for us to fund through fees. So that authority has been added as a result of these amendments. Those are not in place yet. It's giving the authority, whether those are actually exercised. That's subject to discussion and something that we're working towards. It's a way to fund the office in addition to it fully funding by government. But it's really important that there's some key principles here if fees are to come in, that they're predictable, that they're reasonable in the sense that you're talking about nominal fees that one would expect to be paying to a central organization, tied to service and equitable. And so that's something that is likely to be discussed at a future date, but nothing in place at this time. I want to touch on traditional knowledge. There are some clarifying clauses that were brought into the act. So a key element of government generally, but also in the professional regulatory realm, is recognizing how we can address reconciliation with Indigenous people. And there's a specific obligation under the Professional Governance Act for the superintendent to promote that. But we also wanted to do some clarifying clauses because traditional knowledge, particularly when you're getting in environmental sphere, is something that we want to make sure that everybody understood is not regulated through the course of professional regulation. So the other thing that we should just talk a little bit about in terms of new reserve practices. So in terms of some highlights of what's happening under the Professional Governance Act, not all bodies that came into under the PGA had what we called reserve practice, what I was talking about before, the ability to say, I am the only person that can do this, right? And so in the areas of applied biology and agrology, they traditionally did not have any reserve practice. So one of the commitments as a result of coming under the Professional Governance Act was to develop reserve practice for those two professions. And that's recently been done. It was announced the previous September that it was going to be done, and came into effect early this September. So putting that in sort of clarity for your interests, if landscape architects come under the Professional Governance Act, there is an opportunity to explore whether or not reserve practice makes sense for the profession. So that's an important element, because right now, through your current provisions and current act, all you have is right to title. Right? And a lot of this involves modernizing some of these concepts of reserve practice. And so we're right now working with the architects in terms of bringing in their reserve practice, their existing reserve practice, but trying to express it in a more modern way. And one of the challenges that the architects faced is their reserve practice was articulated in their act. So in order to change it, to modernize it, you have to change the act. Back to my earlier discussion, you have to get the interest of government and time in the legislature in order to do that. That's challenging. Under the Professional Governance Act, reserve practice and definitions with respect to reserve practice can be changed by regulation. Much easier process. And you have the Office of the Superintendent of Professional Governance there to facilitate that process for you. So those probably a little bit too much detail in terms of some of the technical enhancements of the Professional Governance Act. But hopefully I was able to weave in my discussion really the essence of what the Professional Governance Act does, which is brings in one act, which has a modern framework, not acts that have been 100 years old or 50 years old, have a common framework for several professions, allows those professions to be added to, creates an organization, the Office of the Superintendent of Professional Governance, to assist, monitor, and provide oversight in terms of protecting the public interest through the main elements of what a professional regulatory body does, which we talked about earlier. Entry into the profession, continuing education, practice, assistance throughout your time as a professional, and complaints and discipline process, as well as ethical obligations and duties through a code of ethics. So one of the key questions, of course, is, well, you brought in this lovely Professional Governance Act. How does it help? Is it having impact? And I'm biased, of course, but the answer to that, I think, is yes. And sort of the four sort of areas that we've sort of talked about, and I've touched on a little bit this already, but emphasis is always good, are these four. Consistent, modern, and dedicated governance, communication and collaboration, Indigenous reconciliation, transparency, and oversight. So I think in my rambling up to now, I've covered this slide. Professions with separate statutes administered by separate ministries, inconsistent, infrequent opportunities to update statutes. We now have this single statute, we have this dedicated office, and we have central government expertise to support regulation in the public interest. Transparency and oversight. So under the previous regimes, there really was no oversight function. Regulatory bodies did self-evaluation. They reported on their performance, usually through annual reports and through their AGMs. but no authority to conduct oversight of regulatory bodies. And for some professions, no requirement to even be registered and under that oversight. So now the superintendent evaluates and reports on regulatory bodies. We're starting that process now. And we'll be fairly shortly releasing our first report related to that. New authority to conduct that oversight of regulatory bodies, and that is based on systemic matters. So if there is a complaint against an individual registrant, that goes to the regulatory body. If you have a concern about that process, singularly, I didn't like the result, it's judicial review. You go to the courts. If you didn't like the process, you can also go to the office of the ombudsperson. But our office, the superintendent, does not investigate individual complaints. We're not an appeal body. But where we see trends, systemic matters, that's where our authority lies. And that's the type of thing that we're trying to address and improve, again, in the public interest. And then, of course, new reserve practices that I talked about, that increases and requires more individuals to be registered and regulated. That's not always the result that you need or want, but in cases where it is, we have that authority. In terms of transparency and oversight, some other things in terms of, we do a lot of guidance development to set expectations, and that's published on our website. Our role and our sort of culture with relate to that is to do this through guidance. Under the Act, I actually have some fairly notable powers, but the idea is not to use those. The concept is to use that through working collaboratively with regulatory bodies and providing advice and guidance as opposed to directives, although there is some authority. The use of lay counselors and committee members ensures that we have requirements to provide accountability and a perspective on governments outside that of the registrants, so that we're bringing in that public interest. We also put limits, not a total ban, but a limits on advocacy. So the role of a professional regulator is to regulate, not to advocate for the profession, stated simply. Now, in practice, that line is a little harder to draw. So we have some guidance associated with that. But what we really want regulatory bodies to do is focus on that central objective of protecting the public interest and its distinct goals in terms of credentialing, practice directives, and complaints and discipline process. And also in terms of, we're seeing enhanced requirements for information sharing. So the member of the public who is looking to procure services of a particular professional, that should be simply accessible on a website. You should be able to find that. You should be able to find whether or not there are any discipline matters or anything against that registrant, so that you can make the decision about who you want to procure and what services they provide and what their areas of expertise are. Because some of the professions that we deal with are very broad. And one of the obligations of a profession is only to act in the areas where you are competent, right? So you'll each have degrees of specialization, regardless of what profession you belong to. And so it's important that where there are requirements by the regulatory body to say you have a specialization in this particular area, for that to be available to the public. So people don't stray across those lines. Generally, professionals don't, because you don't want to do stuff that you're not qualified to do. Communication and collaboration. This is just because we're bringing all the regulatory bodies together, they have opportunities to build from each other. They have opportunities to experiment and share those approaches instead of everybody reinventing the wheel. So we've started the process early on about doing this collaboratively, and we've continued that on with basically monthly meetings of all the regulatory bodies to discuss common issues. We also engage ministries in a separate process so that we create a dialogue between government and the regulatory bodies. So when regulatory bodies are doing something that affect ministries, they're able to tell them and get some input, and vice versa. We hope that ministries will be communicating with regulatory bodies and say, we are bringing this in. Will this have any impact on your registrants? And how do we address it? Creating that dialogue. I touched on Indigenous reconciliation, but a key role as superintendent is to promote reconciliation with regulatory bodies. We're seeing this primarily through education requirements and continuing education of registrants. And as I mentioned, that clarifying provision in the PGA to say where the line is between traditional Indigenous knowledge and practice of a profession. So I hope that gives you a better sense of what the Professional Governance Act is about and some of the areas of interest and some of the areas where I think it's improving the professional regulation in British Columbia. So now I'm going to turn a little bit to the specifics of designation, which will be of particular interest to you. So I'm proud to say that the landscape architects from day one expressed an interest in knowing what the Professional Governance Act was about. And so we started a dialogue with the society very early on to answer their questions, to get their insights with respect to what is called a designation process. So you can, as I said earlier, be added to become under the PGA. And the effect of that is your governing statute will be the Professional Governance Act and not your current legislation. So there's two ways that can happen. As superintendent, I can say, oh, this profession is very interesting, and I think there's a public interest argument that they should be brought under the PGA. I'm going to start an assessment. Or regulatory bodies, usually existing bodies, say, I'm interested in what the PGA has to offer in terms of a more modern statute, a better framework. It exists in an area where my other fellow professions are involved, and I'm interested in having that sort of approach. So that's what's happened here. The society filed an application for designation, the first one under the Professional Governance Act in July 2021. And then when I receive that application, I have to review it and say, am I going to accept this application for review? So that happened in August. And then since that time, my staff undertook an analysis based on the application that was provided by the society. And we recently released our intentions report so that we could have broad input from the public with respect to that. And in that report, the draft recommendation was to bring landscape architects into the PGA. So I determined through that report that designation of the profession was in the public interest, and I'm recommending designation of the Professional Governance Act. That is not where the process ends, however. So we're now in the process of making that recommendation to the minister, the Attorney General. When the attorney has that recommendation, he will make a decision on whether to recommend that to cabinet. If he recommends that to cabinet, that starts the process of designation. So that's exactly where we are right now. We're very close in terms of that process. And so I anticipate that that will conclude in the next month or so. So if that recommendation is accepted, we will begin our work with the society in that transition to under the PGA. And that involves a number of things, making sure your current bylaws are compliant with PGA requirements, changing the board structure and statutory committees to make sure that they're aligned, ensuring that we have a consistent framework for ethical obligations, mandatory continuing education is in place, statutory duty report is understood, and provides opportunity to regulate firms and has the opportunity potentially for clarifying the reserve title, but also reserve practice, which is likely something that would happen later on. So that process will take a little bit of time, although the society has been very keen to anticipate what that would require and put themselves in a position to do that in a manner working with us in a fairly efficient manner, should that to be the decision, which I hope it is. So that's where we are in terms of the process and impacts that. So potentially, if we were to come back and speak to you next year in terms of this process, assuming your annual meetings are around the same time, you could be under the Professional Governance Act. And that will require some change. But I think in general terms, providing that modern framework, updating the tools will allow you to be an effective, a more effective profession in British Columbia and continue on the good work that you are in landscape architecture in the province. And I hope that you see it that way as well. There are a few steps to take, as I said, so I can't guarantee anything at this point because I'm not the decision maker, but that's the recommendation and that's the process. So after all of that rambling, hopefully you've picked up some of that. And if you haven't, there's an opportunity to ask questions.
Well, thanks very much, Mr. Craven. And I'm going to call you Mr. Craven, not Paul, because I'm Paul, and that would just be weird.
Okay.
So you're okay with that? Okay. Before we get started on questions and answers, I just wanted to say two really quick things. First of all, just wanted to acknowledge the work that the OSPG has done in accepting and reviewing our application. And I also wanted to just say that the RRTF, which has now been disbanded, put a tremendous amount of effort into our application, and really just wanted to applaud them. I'm the new chair of the PGA working group, the new professional governance working group that will be working with Mr. Craven's office moving forward. And some of those people, in fact, one person who I'm going to mention by name, Jacqueline Lowe, she was the co-chair with Adrian on the RRTF, and she's agreed to actually help as an alternate chair with the new working group, and I'll be relying on her heavily as we kind of transition into this new phase, hopefully. So we have a plan. I am going to be looking at my friend at the back, Vincent. He's our audiovisual tech. He's going to be taking questions online, and they should show up on screen here. So Jack, if you could, flag me if you see a question up there, that'd be great. And if you have questions, please, if you could stand up and, oh, there's a microphone over here. Maybe I'll grab it from you, Tara. Hang on a sec. Can't see anything anymore. How's that? Oh, wow, great. Okay, so if you have a question, I'll come and run to you with a microphone. Here's one here.
Yeah, I just had a question about the firm registration. I typically like landscape architects, there is a fair amount of like solo practitioners, and I'm wondering like what's the threshold for a firm? Especially like I think we want to encourage new firms developing, and there's a lot of challenges to that as it is. I'm just curious, like how much of a hurdle would it be for like especially like I'm a firm owner and we've been established, so I'm not really worried about it for ourselves. I'm just curious, like how much of a hurdle is it for new firms to pass that as they're kind of just starting up?
Yeah, great question. So first of all, in order for firm regulation to apply to a regulatory body, we have to turn on a green light. So it's not automatic. And so the regulatory body will make a proposal and say, firm regulation really makes sense, and we would like to do it this way. So the engineers, as I mentioned, are the only ones that have done that. And they have a fairly comprehensive program related to that. just introduced. Their registrations with respect to that wildly were higher than their expectations. Their choice, and through their bylaws, they set up what their firm regulation program looked like. Their program did not make a distinction between multi-practicing or individuals. So it applies to sole practitioners. But what they've concentrated on is how do you, recognizing the difference between a sole practitioner and a large firm, what are the requirements and how, and is there certain forms or certain approaches to allow that differentiation? Again, following the principle of right touch regulation. So firm regulation may not happen but for a particular profession, but it's a possibility. Why we like firm regulation, of course, is probably because the things that you all intimately recognize is that where you work impacts how you work. And so the firm regulation program with the engineers really focuses on ensuring that the firm has programs that support continuing education, meeting ethical obligations, those types of things. And the response has been very good. Now, they had a pilot project, a program for many years that fell short of firm regulation because they didn't have the authority to do it. But they were building on something that was already fairly successful. So the society would have to decide that it was necessary, and then is really free to tailor it the way they think is appropriate, because that's the role of the regulatory body, and OSPG is there to help design and build on that.
So my first question, and it's more on the practical end of things. I just wondered how big this is in terms of a department. So what's your annual budget for your department for this year, and what do you expect to be in 5 years?
Great question. So we compete for resources, some governments as well. We are, I think our annual sort of spend is slightly under $1 million. We have on any given day 7 to 8 staff. And so as more regulatory bodies are added on, that's probably will dictate how big we get. We don't feel that we need to be a very large organization. That's not our focus. Our focus is being enough to provide those best practices and do the rules that we can. So probably some growth over in the next 4 or 5 years, depending on what other regulatory bodies are added, and as well as the type of work that we need to do every day. We're fortunate in British Columbia that in this sort of realm, particularly the built environment, the natural environment, we have very strong regulators. There are areas for improvement, no doubt, in all of them. But they come at different places, but we need to help them and assist them doing that. One thing I didn't mention, so I'll mention it now, thanks to your question, is we've established some standards of good regulation. So they're on our website. I think we started with 18, I think we're now up to 20, which sort of set expectations for the regulatory bodies of what we think good regulation is and what we monitor and provide oversight against. So we wanted to do that really early, so the regulatory bodies knew what they were aiming for. And that's a key part of our role, is assessing up against those standards of good regulation.
Okay, so that sounds good, and it seems like it's well set up in terms of adapting and taking input from the various disciplines. So without being very informed, the concern I have as a landscape architect, when we go into a meeting, say it's a big project, and there's a room full of consultants, and each are from a different discipline, and then the project starts, and who does what tends to evolve more than you would imagine, at least more than I imagine. And, you know, more and more the architects and the collaborative design process are insisting that the landscape architect gets involved in the meeting. And a lot of the stuff we talk about isn't landscape architecture. So I'm a little concerned about the exclusive practice act applying to landscape architecture, which I always saw as somebody that has a fairly broad understanding of a lot of things, whereas there's special, even engineering. So we're not gonna start engineering projects, but if we're restricted to really weigh in or be part of a collaborative design process because they have exclusive practice rights to whatever, it's just hard to imagine that that's not going to bite into the role the landscape architect plays in a better solution in the built environment and the natural environment. So that's I can't even imagine how that would get quantified. So that's a concern.
Yeah, and so one thing that we're very cognizant of is what impact we have on the ground, right? And so we don't want to be regulating or changing things that are working well on the ground. And so in many cases, some of this stuff is to ensure that the status quo continues. But practices evolve, issues evolve. And one of the advantages of being under the PGA is all of the professions that are working together every day under the same regulatory framework. And that allows collaboration with the regulators to draw lines or identify gray areas and make sure that those are done appropriately, as professionals do every day. And to the extent that there's friction related to that, you now have an oversight body, the superintendent, that makes sure that that conversation is going on and has some authorities and ability to intervene when necessary to make sure that things don't get out of hand. So I think there's what we're seeing is a lot of benefit by the fact that the regulatory bodies have to work together and build off of each other. There is a tendency in the older system for there to be a competition. But because you're under the same ethical obligations and sort of same practice obligations generally for your disciplines, then from a public safety point of view, a public interest point of view, I'm happy that you're in the family, right? And we should be able to sort those things out within the family. Sometimes families have disagreements, but not often.
I think I'm next. I work for a regional government. We've noticed already that there are implications from the EGBC reserve practice that are infecting our work. The work that we used to be able to do, we're no longer able to do any longer in-house, and we're having to hire out consulting engineers. It's affecting our budgets and timelines. How is reserve practice set? Some of the, I see maybe some places where traditionally landscape architects were allowed to practice where we are not able to practice any longer. And is there ability to fine tune that between professions going forward?
So reserve practice is set by regulation. So, and what we tried to do in the first instance of bringing in reserve practice for engineers in particular was to maintain the status quo. Those things can be tweaked. Now, part of that may be the bringing in a firm regulation and some tightening up of understanding about where people should be practicing or not practicing. But part of the thing that we do at OSPG is try and get a sense and are a body for people to talk to where there may be unintended consequences as a result of reserve practice, those types of things. It's not a perfect science. and identifying what your reserve practice is in any given area is difficult. So you kind of have to do it very generally and then let practice sort of evolve. And one of the directives that we did issue out of the office was for every regulatory body to have explanatory materials for the public and for the registrants on what reserve practice is and what it means. And those will also continue to evolve as we run upon circumstances, so that that description becomes something that is widely understood. It's never going to be completely, here's a list, because you don't want just a list of everything, because that limits flexibility, but it needs to be defined enough so people really generally know where they're at.
Jackie, I see your hand, but I'm going to read a couple of these questions first. So, Mr. Craven, is there any reason that the recommendation for designation would not be successful?
Well, would like to think that the minister would support the recommendation I make, but there are other considerations that that the minister and government generally have to take into consideration. Really not my place to sort of speculate one way or the other. This is kind of a unique time in terms of the process. So rather than speculate, but I think the recommendation in the report make it a compelling case.
Next one there is, I'm particularly interested in this one. Given the expansiveness of the project of changing bylaws, how would you recommend that a profession like ours begin that process?
Well, we've had the advantage now, the OSPG, of going through this with 5 regulatory bodies. So there are now 5 sets of bylaws that have been deemed compliant with the PGA. And some of them are constantly being tweaked and revised as we change things. But that's a good starting place, right? So evaluating your bylaws currently versus the bylaws that are for other regulatory bodies. So there is no shame in looking, borrowing, stealing, and then tweaking to your own circumstance. And there's a variety of ways that you can do that. So that's one place that you would start.
Jackie, do you want to jump in here?
I am. Thank you so much for answering all these questions. I know there's a very broad array of topics. Just kind of going back to some of the earlier comments about reserve practice. I know that you really highlighted that in your presentation, and I'd like to believe part of that is that, you know, we had expressed that there may be some areas where if we are accepted into the PGA, that it may make sense for landscape architects to have certain areas of reserve practice. But I just wanted to draw some light and attention to the other definitions around shared and overlapping practice. And just for the benefit of the room, what we've learned in dialogue is that from a point of definition, there's things called points of intersection and points of overlap in our day-to-day practice. So a point of intersection might be if, let's just say there's a structural retaining wall. You would have potentially a structural engineer designing the reinforcing of the wall. Perhaps the landscape architect is specifying the materials. Perhaps they're involved in some of the topography and the grading of the wall, but all the utility infrastructure and drainage of that wall might be done by a civil engineer, and all the soils and loading requirements of that wall might very well be identified by a geotechnical engineer. So that's an example of points of intersection in our profession, where it takes many professionals to coordinate on one element of design, whereas overlap would be multiple professions being able to do one aspect of a project, but one of those professionals need to, for the case of that particular project, take a lead on it. So an example of that might be, you know, we're downtown, say there's an urban outdoor plaza, landscape architect or an architect or a civil engineer for that matter may all be the right qualified individuals to potentially take a large hand in leading the grading design of that plaza and integration of that plaza. Where that gets important is that there is then definition of what I learned was called shared overlapping practice that could also be identified within acts and legislation. The point of that, from what I've understood, was to still be in the protection of the public and the public interest, to be able to go, okay, you know what, you still need to be one of these professionals with these qualified backgrounds to be able to take on that level of risk and technical knowledge and understanding to perform those aspects of work. And so that would also very much be part of the process, from what I've understood over the last few years, is not just putting definition to the potential of reserve practice for landscape architecture, but also mutually identifying those areas of overlap and shared practice in more of a written aspect and form, so that, you know, we don't potentially encounter issues down the road where other practicing disciplines who do have more modernized legislation are the only ones acknowledged by government through that updated legislation to be able to take on those certain tasks. So that's a huge component of some of the background thinking and inspiration from the former task force and supported board and organization in wanting to pursue our application to the PGA. And so, Mr. Craven, if you just wouldn't mind elaborating further on perhaps maybe some of the process that you had with the original 5 bodies in perhaps identifying intersections and overlaps and how you kind of work that out in your process of updating their legislation?
First of all, did you want a job? Really good description of some of the challenges and some of the elements that we need to go through in terms of overlapping or shared areas. And so that starts with the conversation in terms of reserve practice, but is a constant discussion in terms of articulating those, because it's those practical examples that you give are the ways that you tease those things out. And then part of that is the descriptive materials that we've talked about and dialogue between the regulatory bodies in order to identify where those are and what it truly is, right? And how does it operate on the ground? And how do we ensure that there is a common standard or practice where that's appropriate, right? Because you don't want circumstances where an engineer is doing the same thing as a landscape architect, but they're held to different standards or approaches, right? So that has to be worked out between the regulatory bodies. So a lot of that is dialogue and collaboration between the regulatory bodies, generally done on their own between each other, but the OSPG can supervise and assist in those dialogues as necessary. And it's not a process that sort of ends, it has to emerge as practice changes.
Are you okay to take another question or two?
I'm here all night.
Right on. Okay. Can you expand on the distinction between professional knowledge and Indigenous knowledge?
So a tricky area, I guess, where I came across it most of my professional career is my work in the environmental assessment office. And so in preparing assessments related to what the impacts of a particular project might be, you had what we would call the scientific knowledge elements done by professionals. But you would also, in many cases, when you were engaging Indigenous governing bodies or organizations, they would bring observations made passed on from time immemorial in terms of their traditional observations of what happened in a particular area, where particular wildlife lived, or where particular plants and practices were done. And that was actually helpful in terms of the general overall assessment and setting up mitigation. And so in regulating a profession, we want to acknowledge that traditional knowledge, traditional Indigenous knowledge, is its sort of own sphere. And we don't want to inadvertently say to Indigenous people, you can't practice in that area, or you can't practice your traditional knowledge because it's regulated by this regulator. That's broadly what we're trying to do here, to provide space and ensure that those things can work in complement, because they, in my experience in environmental assessment, both help that process of determining what the impacts of a particular project were and how to mitigate them.
Relates to restoration and ecology, but what if someone wanted to install a clam garden, for example, and it required a lot of work below the tide level, and there's going to be a lot of grading, and could they do that in their traditional way, or would they have to work with a regulated professional to do that work?
Well, I guess it depends in this sort of context, and I'll remind you, I'm a lawyer. In terms of the regulatory design related to that, you're going to have to go through the process and have the particular professions. And if that requires them to sign off on a particular thing or design a particular thing because an authority having jurisdiction requires that doesn't change that process. But what we're just trying to ensure, and in doing so, the best case scenario is that any traditional knowledge in that thing is incorporated, and design may address some of those issues. But we just don't want to impact that practice and say one cannot practice in that area as because it's regulated in that way. Right, particularly when you're dealing with areas of reserve practice, where you're saying that only these individuals can practice in this area, because it could be misinterpreted as suggesting that those traditional knowledge and skills can't be applied and are regulated by the regulator, as opposed to traditional Indigenous practices.
Any other burning questions from the floor? Okay, I think we'll leave it there. Here's to hoping that you get really sick of Jackie and Al and I and others that have volunteered for the our working group, and that we see lots of you in the future. Yeah, thanks again.
Yeah, thank you for the opportunity.
Yes, thank you very much. This was very interesting, and it's great to have you here. It's that immediate knowledge of who is the superintendent. Here he is, and visiting Vancouver and meeting with us. It's wonderful. So now we're going to thank everyone for joining us online and in person for this event. We now welcome you to join us for refreshments. We are grateful to Joel Fransk and his team at Green Theory for their generous support for the meet and greet networking reception. Joel, please stand up and be recognized. Joel has the representatives here in the corner. Thank you. Some applause for our sponsors. With the support of our generous sponsors, we can continue to offer valuable programs, services, and activities to BCSLA members and associates. Please remember to consider carpooling home tonight with a designated driver, take public transit or ride share. And with that, I think we can start having refreshments. Thank you, everybody.